Good morning, everyone, and welcome. Thank you for joining us for our panel titled, What to Expect When You're Expecting Privacy Regulation from the Government. My name is Kenesa Ahmad. I will be moderating this panel today. I'm an associate at Promontory Financial Group's global privacy practice. I live in San Francisco. Prior to joining Promontory, I lived in the DC area and served as a legal and policy fellow at the Future of Privacy Forum. So I'm excited to be here today talking about these critical issues. So as we know, data collection is ubiquitous, and increased collection and use holds a lot of promise, but also raises important issues relating to consumer privacy and data security. Almost every day we learn about another company that suffered a massive data breach. It's become really public, or we're learning about new technology that raises complex privacy concerns. So these are threats that require constant vigilance, and in the past have sometimes fallen outside of the scope of many entities' traditional risk mitigation practices. So this raises the issue of government involvement. When and to what extent should the government step in to regulate or monitor these entities? So the purpose of this panel is to provide varying perspectives about the appropriate role of government in regulating these matters. So we're fortunate to have a very distinguished panel with us today. We'll start with letting the panelists briefly introduce themselves, and we'll get right into discussion. So I'm going to give the panelists the floor for the first half of the session, and appreciate if you would hold all questions and comments until the second half. So let's start with you, Raegan.
Hi, I'm Raegan MacDonald. I'm European Policy Manager at Access. Access is an international digital rights group that combines tech and policy, and we fight for open and secure communications for all. I'm based in Brussels. I work in the Brussels bubble. I work on EU policy issues from data protection to privacy, net neutrality, and censorship.
So thanks for having me here. I am Cora, and I am an attorney in the Division of Privacy and Identity Protection at the Federal Trade Commission, where I work on data security and privacy enforcement and policy issues. So before, oopsie. No, that's okay. Okay. So before we get started, I have to give a disclaimer that the views that I'm going to express here are only my own views, and they don't represent the views of the Commission or any of the commissioners.
Thanks. My name is John Verdi. I'm Director of Privacy at Initiatives at NTIA, the National Telecommunications and Information Administration. NTIA is a bureau within the U.S. Department of Commerce. We are the principal advisor to the President on telecom issues, including internet issues. I am a lawyer, but please don't hold that against me. I am not a lawyer in my current capacity. Prior to going to law school, I was a technologist and built secure websites and things like that. I will also say that my views here today do not necessarily reflect those of NTIA, the Department of Commerce, the administration. They may not even represent my own views. I may be borrowing them for someone else for the purpose of this panel. So thank you so much.
Thank you, and welcome, panelists. I'd like to start with a question for each of you to respond to. So in your current positions, what do you think are some of the most important or most effective efforts that you're now making to help protect consumers or help consumers protect themselves?
Yeah, so I may pass that. So at the FTC in our division, what we try to do to protect consumers is do it through a mix of law enforcement and policy work and outreach to businesses and consumers. And I think that sort of all three of those efforts are significant to help achieve our mission. So I'll mention just a few highlights in those categories. But on the enforcement side, as many of you probably know, our core enforcement statute is Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices in or affecting commerce. And so that's a fairly flexible standard, and we've applied it to a broad range of industries, including things like retail, mobile, social networking, and to a wide range of types of information, financial information, health information, and other types of personal information. To give you just an example of one of our recent enforcement matters, one of our recent settlements was with a company called GMR, which provides medical transcription services. That company hires contractors to download audio files, transcribe them, and upload them, and for a period of time, those files were actually made available on the internet. And so despite promises by the company that information going through the system would be kept highly secure, that in fact was not the case due to a number of data security failures. And that is sort of a good example of the type of case we'll bring, which often involve, on the data security side, multiple data security failures. In addition to Section 5, we also enforce a number of other privacy statutes and rules. For example, the COPPA, which involves children's privacy, Gramm-Leach-Bliley, which involves financial information, and other types of rules like that. So moving quickly to the policy side, I just mentioned two of our recent efforts. One is a workshop that we had in the fall on the Internet of Things. And we had a panel on connected home, a panel on connected cars, a panel on connected health and fitness devices. And we also had a panel about the privacy and security issues related to all of those. And what we were doing there was, as we often do kind of in our policy efforts, is bring together a diverse group of stakeholders to address privacy and security issues in emerging technologies. And then the last thing I'll mention on the policy side is our recent data broker report, which was the result of a study of 9 data brokers that revealed a number of things about the industry and also called for increased transparency in that area. And both the data broker report as well as a lot of materials from our Internet of Things workshop are available on our website, which gets me to the last thing that we do, which is consumer and business outreach. And on our website, ftc.gov, or our business website, business.ftc.gov, you'll find a lot of those materials as well as other guidance. So for example, information for app developers, as well as general data security guidance. So, and I think I will stop there. Thanks.
Thank you, Cora. Do you, John or Raegan, have anything that you'd like to add?
So, as an advocacy organization, we really focus on the privacy or the rights of the individual. As an international group, we use international standards to guide human rights. In the EU in particular, we use the Charter of Fundamental Rights as a reference. So I will be, I guess, the token EU perspective on this panel. So just one point before I get into some of our initiatives. We come at this whole privacy and data protection issue from a different angle. The use of the word consumers, for instance, implies, at least in the US context, that you have to purchase something in order to have certain kinds of rights. But in the EU, it's a fundamental right, both privacy and data protection. And a fundamental right is basically granted to everyone, fundamentally. So that's how we approach this issue. And we have been working on privacy since our founding in 2009. I'll talk about 3 initiatives that are focused on privacy and security and data protection from 3 different angles of reform. One of them is on the corporate side, one on government, and one user focused. So on the company reform side, particularly after the Snowden revelations, we launched a campaign called Encrypt All the Things. And you can find that on encryptallthethings.net. And this is giving companies that collect and process data 7 actionable steps that they can basically do to better secure their data and to bring the line of security much higher, to make basically government surveillance much more difficult to do and much more expensive. The second one which is more government-focused, has been a lot of our work in Brussels, actually, and that's supporting the European Commission's privacy reform effort in the proposal for data protection regulation that was tabled back in January 2012. This regulation would be a game changer, quite frankly, for a lot of the companies operating in the EU. One, it would be harmonizing all of the different rules. Currently in the EU, there's 28 different privacy implementation standards. This would be one, which makes everything significantly easier. Two, it would give a lot more control to individuals over their information. There's data portability, the right to access, the right to erasure, and basically enhancing control for individuals over their personal data. And it would also include enforcement rules. So currently, one of the biggest problems in the EU with regards to enforcing these data protection rules is the fact that a lot of the data protection authorities in different countries have very different levels of enforcement capabilities. In Belgium, for instance, there is basically nothing except for a note that you can write to a company. There was a very large-scale data breach that the National Railway System had last December, and the most that the Data Protection Authority could say was, "Please stop that." So there wasn't really much that can be done. So this regulation would improve that. So not only for international companies operating, but also EU companies. And then from a user-focused point of view, privacy and security is obviously a center core of our work. And we are half policy, but we also have a tech team, and we have a digital helpline. Which is basically established in different parts around the world, in Costa Rica, in Tunis, soon in the Philippines, where we provide on-the-ground support to users, to bloggers, human rights defenders, to learn how to protect themselves and to use security tools that they need in order to protect their privacy, and in most cases protect their safety. So I'll stop there.
So, unlike the FTC, NTIA does not have enforcement authority. We do not have rulemaking authority or regulatory authority when it comes to privacy issues. The NTIA has some rulemaking authority regarding spectrum, but that's not the area that I work in, and it really isn't relevant to the privacy stuff. But on the privacy front, we're not an enforcement entity. We don't have rulemaking authority. But what we do have is a mandate from the White House to bring stakeholder groups together from business, academia, government, and civil society to craft codes of conduct to implement the administration's Consumer Privacy Bill of Rights. Consumer Privacy Bill of Rights is a document that was released and under the president's signature 2 years ago, calls for a number of different things in the consumer privacy context, but essentially, at its core, what it calls for is a minor restatement or rethinking of the traditional fair information privacy principles, and the implementation of those principles through multi-stakeholder codes of conduct as well as baseline consumer privacy legislation. And what we have been working on most recently has been convening stakeholder groups around topics like mobile device transparency, how to best communicate privacy disclosures on very small screens, on devices that collect lots of data, including sensitive locational data, sensitive health data, sensitive financial data, and how those disclosures can be made more readily understood, more readily acted on by users, and trying to empower users in that way. And we've also been convening a separate effort on facial recognition technology, which is an issue that the Commission has done some really meritorious work on. They had a great workshop a couple of years back. They have a great staff report that's out there. And there is wide, broad consensus in the consumer advocacy space, in the corporate space, in the academic space, and amongst technical experts, that facial recognition technology is a technology that can enable really beneficial, innovative uses of technology, and at the same time can enable and does raise serious questions about privacy. So we've been convening those groups. Those groups have been making headway, working together sort of across some of the traditional boundaries between the advocacy groups and the companies and the trade associations and the academics and the technologists. And they've been making progress. I think that everybody acknowledges that the multi-stakeholder model is a model that's core to the architecture of the internet and the innovation that the internet has spawned. At the same time, it can take a little bit longer than other models. It can be a little bit messier than other models, but ultimately I think it comes to conclusions that are more workable for all the players in the space, for consumers, for companies, and for government, than other models which have a more top-down regulatory approach. So that's what we've been focusing on. We recently released a request for comment on how the big data reports that were published by Councilor Podesta and the PCAST group ought to be accounted for within the model of fair information practice principles, or whether those principles simply take account of big data developments as they stand. So we look forward to hearing back from stakeholders in August. There's about 60 days between now and then where folks can file comments with us about what the administration ought to do to try to take account of big data analysis and some of the privacy challenges that come with that.
Thank you. So those all sound like welcome efforts and developments. So, a common theme that I noticed in all of your responses was the importance of developing robust public-private partnerships or an outreach to consumers and other entities. So continuing on that thought, it seems like a common dilemma, and I see this in my work frequently, is for a lot of companies today, is balancing transparency with level of risk exposure. So on one side, there's the desire for transparency and openness with regulators, which allows companies to identify and fix deficiencies where they need to. And then there's also this need to defend and protect your organization from potential regulatory action or lawsuits. So how can companies achieve this balance and after an adverse event, or I mean, if you're anticipating one, how can companies really meaningfully engage with the FTC and other forums without elevating this risk?
Sure, that's a good question. I would say that, apologies to everyone's ears here, that certainly there are companies who will come in and meet with us, as they're developing products and services. And we don't approve of products, we don't greenlight products, but we will offer feedback where appropriate. And so one piece of advice I would say here is as you're thinking about and trying to assess your risks and vulnerabilities, I would recommend do so as early as possible in the process, because then it's really helpful to kind of build in these types of protections into your products and services. And another thing that I would go back to is the guidance that we have on our website, because even if you don't want to come in, I think we try to be very transparent about the kinds of things that we think are important. And we put those in a number of documents on our website. And you can also see the same things kind of reflected in our cases. So for example, if you make a promise about how you're going to collect or use, share consumer information, live up to that promise. That's one of our core principles, and it's you will see it again and again and again in all of our materials. So turning to sort of after an adverse event happens, I think my message there is that the sort of the touchstone of our data security enforcement is this idea of reasonableness, right? So what is reasonable data security given the circumstances? And so some of those circumstances might be how big you are, the size, the complexity of your business, Another circumstance is what type of information you collect and how much of it you have. You know, another circumstance is, do you have multiple platforms? Do you have a website? You know, do you have an app? If so, you should be thinking about these things across all of those platforms. And then it's also important, I think, to update as necessary, because your business needs change and the industry that you're in probably is also evolving. And so that's kind of a long way of saying, like, well, you know, what am I getting to here? For companies, you know, what I think this means is just because you have an adverse event, it doesn't necessarily mean you had faulty data security. And so, you know, as that process is kind of, you know, starting, you know, I think we recognize that you can't believe everything you read in the paper. And you know, there's definitely an opportunity to tell your side of the story if in fact you have tremendous security and you know, a very negative event just happened as a fluke to happen to you. So, you know, we close many more investigations than we proceed with, but all that being said, we do expect companies to see if there are you know, fixes, low-cost, reasonably available fixes to their security risks, and address those risks as appropriate.
Thank you. John or Raegan, do you have any comments you'd like to add?
The only thing I'd flag is, you know, again, we don't have enforcement authority, we don't have regulatory authority, but one thing we have heard as we've talked to folks in the business community and the security community is that it isn't just the dichotomy between the incentive to be upfront with your customers and potential enforcement actions. In addition to the incentive to be upfront with your customers, there are also information sharing arrangements within industry that companies would like to pursue on the security front. You know, sharing data about cybersecurity threats, for example, that they are in some ways constrained in doing so by antitrust concerns. That companies are very sensitive to the notion that when they get together as an industry and talk about security threats, there are potential antitrust issues there. Not that it's necessarily precluded, but there are potential issues. And I think one thing the administration has done on the cybersecurity front and on the critical infrastructure front is to try to figure out a way to incentivize that sort of threat sharing, whether it's between private entities and the government, or amongst private entities, or between the government and private entities, while at the same time preserving the antitrust obligations surrounding competitiveness issues. So that's just one thing, you know, just to put a pin in that issue. Some of these information sharing, either arrangements or ad hoc activities, can benefit the broader security infrastructure. It's just you have antitrust concerns to deal with it at that stage.
Great. So here's another question for all the panelists. John, I know that you mentioned the facial recognition effort, and Cora, you mentioned that, you know, frequently you're closing out a lot more cases than you're actually pursuing, and maybe that's in part because you realize that it's not an area that needs a quote-unquote decision to be made just yet. So, are there certain areas where you'd be reluctant to, or where you think regulation can't adequately address certain consumer privacy and security concerns? And how does this help shape or drive your agenda?
Sure. So, you know, one area when we take a look at what sorts of topics we want to convene stakeholder groups around, one area we look at is, one, is there a robust existing statutory regime in place, right? So with regard to financial data, the GLB regime is in place. Folks can talk about updating it, folks can talk about modifying it, folks can talk about positives and negatives of that particular regime, but there is in fact a robust statutory and regulatory regime in place concerning financial data. Health data, you have a similar situation. Online data concerning children under 13, similar situation, robust infrastructure in place. Isn't necessarily something that we would absolutely never convene a group around, but we would be very reluctant to do so because, we look at that and we say, part of our role at NTIA is to try to fill gaps between what the FTC is doing, what Congress has done, what other regulators in the federal government and at the state level have done. So I think that's one thing that kind of colors how we view those issues and topic selection and things like that. Second thing is, we look for a true consumer hook. One of the basic ideas of the Consumer Privacy Bill of Rights is that privacy rights are incredibly important given the difference in power in the relationship between companies on the one hand and consumers on the other. When you look at different sorts of relationships, like B2B relationships, those relationships implicate lots of data security issues. Those relationships can implicate privacy issues for secret information that companies hold, not information, not PII about individuals, but trade secret type information. We essentially take the view that those relationships are self-regulating to some extent. They are arm's length commercial negotiations between peers, and to the extent that they deal with information that is sort of corporate information that isn't consumer information, we're reluctant to sort of convene groups around something like that. Because what we're really trying to address is how consumers relate with companies, how consumers relate with each other, how consumers relate with organizations. And we find that to be the really constructive place where we can kind of add value. I don't know if that makes sense.
I'd just like to add, first of all, I second what John said about needing a consumer hook at the FTC. We also are looking for that. In an effort to protect consumers. But in addition, we get our cases in a number of different ways. So we get them from consumer complaints, from consumer group complaints, from reading blogs, academic papers, other ways that sort of people will bring issues to our attention. But in addition to that, there may be particular areas that we are focused on. And when that happens, for example, if there's an emerging technology that, we think, might raise potential consumer protection concerns, we might sort of try and keep abreast of what's going on in that area, with an eye to sort of seeing if, in fact, there are, privacy and data security issues there. And another way we sort of will try and keep on top of certain emerging technologies is through workshops that we may have, which we do periodically. For example, we just recently finished up a set of three, we call them our Spring Privacy Series, so 3 very short seminars on different emerging technologies.
Raegan, do you have any thoughts?
I have lots of thoughts, but I wanted to say something on risk and transparency, and I'm actually glad that both of you are here more or less on a personal capacity. So transparency, even in the FTC report on data brokers, I really like it. It's great, and the big data report from the White House also nice. It's nice to see from, well, I'm Canadian, but I lived in the EU, so it's nice to see from an EU perspective that there seems to be more of a reconciliation of these discussions on privacy, even if it's from a consumer perspective, on how to mitigate these risks, and having the government admit that yes, big data can cause serious problems for discrimination. It can undermine constitutional rights. It's not just a consumer problem that they have to figure out themselves, but this is a core principle that undermines the freedoms upon which our societies are essentially built. That being said, I've heard there is a focus on transparency often, and this is a systemic issue in the tech policy world, and I see transparency as kind of a frenemy of digital rights, in that it's really great, but only if it is accompanied with actual change in practices. If you have a house that you don't want to get robbed, and the thief says, well, I'm going to rob it, but I will film the whole thing and give you aggregate information on what I stole, that's really not helping the situation so much. And so there is still this focus on transparency, and it's a very nice thing, and it sounds very great. But what we really need, and what the FTC in all its capacity can do, is to push as much as possible to actually get real change and real reform in the data broker community and beyond. And on the risk-based approach, Cora, you mentioned a nice term, an adverse event. That if a company, that was really diplomatic. That's really diplomatic. If a company has an adverse event, like a data breach, let's just say it. And that's only one of the issues. I mean, the other issue could be that maybe they don't have enough security, and it makes government access to this information much easier. So this risk-based approach has actually come up in the discussions in the EU in the proposal for the new data protection regulation. And one of the principal problems of this risk-based approach is that it gives companies a lot of power to basically decide what is a risk for individuals, and for a company that obviously wants to avoid the bad PR associated with an adverse event, their natural instinct would be to minimize this internally and to not report it. And that's one of the things that we hope will change in the EU and in most other places around the world, is that the government is actually responsible for laying down these baseline rules to compel companies to report on these breaches, and actually to prevent them from even happening. So that's what I wanted to say about that, I guess.
So Raegan, you mentioned the importance of real transparency. It's a phrase that we use, a word that we use a lot to describe efforts being made. But I'm wondering, John, you're overseeing this facial recognition effort right now. How do you think, and I'd be curious to know what Cora thinks as well, how this effort is actually going to shape industry behavior?
Well, let me just start off. I'll talk a little bit about, John referred to earlier, some of the FTC work in this area, and then I will turn it over to John to talk about how that multi-stakeholder effort is going. But so, as John mentioned, we had a report which we issued in 2012 on facial recognition technologies, and it was not a template for law enforcement. It set forth best practices and really focused on how to implement the 3 principles that we set forth in our 2012 privacy report, which is privacy by design, simplified choice, and greater transparency in the facial recognition area. And so, for example, some of the best practices included having companies design their services with consumer privacy in mind, developing reasonable security protections for the information that they collect, and methods for determining when to keep that information and when to dispose of it, considering the sensitivity of the information when developing these technologies. So, for example, recognizing that digital signage may not be appropriate in areas where lots of children congregate. And also making sure that consumers are aware of when facial recognition technologies are being used when they come into contact with them, so that they're able to make choices about how that data is being collected.
Thank you. So on the facial recognition front, just to drill down a little bit on these processes that we've been convening, we have been sort of setting the topic and scheduling the meetings and inviting folks to participate, and they're big public meetings, anybody can come. But what NTIA has not been doing is holding the pen, right? We are not sort of acting as what I would consider to be an active chair in the process, where we make determinations about what language goes in or what language doesn't go into a code of conduct. That's all the stakeholders' work. That's the folks from industry, the privacy advocates, the techies, the academics who are in the room. They hold the pen, they do the drafting, they make the decisions about the process. And one thing that, what that can sometimes do is surprise us at NTIA. It can surprise me personally, because if I were to game out how I think the process is going to go, I'm invariably not going to do much better than a coin flip in terms of guessing the result to any particular issue. And that was sort of a humbling experience early on, because I thought I had a pretty good line on how this was all going to work out. And it turns out the stakeholders knew better. And we had been saying that since the beginning, but it really has borne out in both the mobile process and the facial recognition process, which is a very long way of saying, Raegan, when you talk about transparency not being sufficient, right? One of the things that the group has done, and I don't know if this is to the horror of the FTC or not, or to your personal horror, is that they have basically blown by transparency very quickly in our process concerning facial recognition. And basically said, yeah, transparency is important, and we'll figure out some language to promote it, and we get that, right? And it's probably going to look different on a game console in your living room than it is in a retail store when you walk in. But that's details. We'll get to that later, right? And what the group has really done a tremendous amount of work on is this question of control and consent, right? And there's been a lot of discussion about control over biometric identifiers, whether it's an individual putting the biometric on their own mobile device for authentication purposes, and sort of they control it and it never leaves the device, and how that can be secured and how that control can be facilitated. It also goes to how a retail store, for example, that collects a biometric from an individual provides control to the individual. Do they get a consent at the time of enrollment? Do they get consent at the time of scanning? And then for downstream uses, what happens if that retail facility wants to share the biometric? Okay? What happens if the consumer wants an online service to share the biometric to facilitate some transaction that the consumer is trying to engage in, right? And that has been one of the core issues early on in that process. Not the transparency, not how do we tell folks about stuff, but more how do you facilitate control, how do you facilitate consent? And there have been a diversity of views about that, but what the group is kind of inching towards is a focus on that enrollment threshold. Enrollment in a biometric database as being the critical threshold, and then sorting out the access and accuracy issues and the security issues and the transparency issues as flowing from that. And strikes me as a perfectly plausible way forward, and we're certainly supportive of all the work everybody's doing, but not something I would have expected going in. I would have expected folks to latch on to transparency right up front, perhaps to latch on to security given the sensitivity of a biometric identifier, right? But the group decided what they wanted, what they wanted to do, and we're supportive of it, and it seems like they're making progress. So that's where we're at on that front.
Can I just clarify, what do you mean by enrollment? It's in, like, from the
Sure.
consumer perspective or the company?
So enrollment ends up being this term of art. I learn a ton about this stuff as we bring in technical experts to brief the group.
Yeah, I don't speak DC. I speak Russian.
Yeah, this ends up being techie, actually. So I don't know whether it's DC or Silicon Valley or what, but apparently, whether it's facial recognition or fingerprints or iris scans, any sort of biometric identifier, there's basically a term called enrollment that distinguishes a very specific practice in the biometrics field, okay? And what happens is enrollment is when a biometric identifier is entered into a database and retained for the purpose of performing some later transaction, whether it's authentication, whether it's identification, whatever it is, right? And one of the reasons that this term is used is folks talk about it as being distinct from the initial scan that happens, right? So for example, one could imagine a retail location having an existing database of criminals, right? A publicly available database of face prints of people who've been convicted of retail theft, right? And they never alter that database. They never add anybody to it. They never delete anybody from it. They just have a publicly available database. And everybody who walks into the store, they scan them, right? And if there's a hit, security gets alerted, and they follow somebody around, or they do a visual confirmation, or they call the cops. They do something, right? But if there's no hit, all the data is discarded, and there's no record of it, right? So those sorts of security systems can be employed in that context. They can also be employed in the building access context, right? So if your apartment building, instead of having a doorman or a security guard, has a face scanner, and you have an existing database of all the residents of the building, somebody approaches the scanner. If you're a resident of the building, the door unlocks. If you're not a resident of the building, we don't retain your information. We don't do anything. We just don't unlock the door, right? You have to buzz up and have your buddy come down and let you in, or push a certain code or do something like that, right? So the enrollment is when the biometric is generated, retained, and then used for some later purpose. And that's what the techies have told us, and that's sort of the threshold point in the process that some of the stakeholders have latched onto. Does that make sense?
Yeah, so like in data protection speak, that would be like purposive protection, more or less.
So, and I just wanted to sort of make a personal plug for transparency here. So certainly other, other protections are great, and I think significant, particularly given, the greater amounts of information that are being collected through all of these connected devices we have. That was very clear in our Internet of Things workshop, and also in this Spring Privacy Series segment on consumer-generated controlled health data that I worked on. There are a lot of challenges to notice and choice. Are consumers even reading privacy notices? But all of that being said, I think there is a benefit, a significant benefit, to short, clear disclosures. It gives consumers information about how they can control the sharing and the collection of their information. And so, while indeed I may think personally that other protections are also, things that should be moving along as well, I do feel like a significant part of it is still transparency.
I just want to make a caveat that I'm not anti-transparency. just that it's just not always enough, and what is really important is the actual action and ensuring that people have control over their data. And for instance, I mean, like this facial recognition thing, it's slightly terrifying. I mean, and any company, any individual can just set up a facial scanning recognition system, and you just have to hope that they're clear enough about it so you can understand what they're doing with your data, which is completely different. And the FTC's top complaint for the past 11 or 12 years has been identity theft. So this is a perfect instance where transparency doesn't necessarily stop these problems from happening. And at what point does the discussion, and maybe this is something you can comment on in your personal capacity, at what point do you require more enforcement and more of a baseline standard? Like the Consumer Bill of Rights is great, but why isn't that enforceable? And the principles that you had mentioned on the best practices, also great, but is it really that effective unless you can actually enforce it?
So we actually have, I think, about 10 minutes left. I wanted to open it up to the audience to see if there are any questions, comments.
Well, I'll ask a question. What should the role of government be post-breach? Should it bring the hammer of enforcement, or should it try to encourage sort of find and fix? And because the implications for that answer are, organizations that struggle, legal wants to protect and defend, and the compliance folks kind of want to find and fix, but compliance, find and fix can create a roadmap for plaintiffs' attorneys, the board being sued, the regulators that are going to come in. If an organization cooperates, should it be, see that 20-year consent order drift down to 15, 10, etc., the fine be less, the press release highlight the cooperation? What's better for the public long term? Should it, be that hammer, or we're going to work with you a bit and, feel your pain? Cora, you pointed out the easy one, the reasonable. If it's reasonable, the company should argue that. But what about when it hasn't been reasonable?
Yeah, I mean, unfortunately, I think it depends on the circumstances. I think certainly, as an enforcer, I expect companies to find and fix. That's regardless of whether or not there is an enforcement action coming down the road. I think as a sort of a responsible corporate action, if you suffer a data breach or adverse event, then I think you should assess what your vulnerabilities are, and fix them. You know, where there have been, you know, particularly in cases where there are sort of multiple, you know, multiple data security failures, you know, I think that is potentially a case that is ripe for enforcement. And I think that, you know, I think enforcement definitely plays a significant role in sort of sending out to the marketplace, you know, here are the practices, you know, that we have found to be in violation of our enforcement statute. And so it's significant.
But you could encourage find and fix by, say, taking a 20-year consent order and moving it to a 10. Should you take that into consideration? And Raegan, I'm curious, what do you think from the consumer perspective? Do you think better long-term for the consumer as well, so that everybody?
Well, I mean, from the way you described it, I don't think it's actually one or the other. You said, you know, there's the hammer approach and then the let's work with the companies approach. And I think both could be achieved. And this question of when is it appropriate for the government to regulate on these issues, this really often comes down to, I don't know if it's cultural or societal, definitely institutional differences with the U.S. and not only the EU, but most of the world in how, what the government's role is. You know, the United Nations has the Ruggie Principles, which basically says that it's the government's duty to protect human rights and the corporate responsibility to respect human rights. And both entities have to ensure that they're providing remedy to consumers, to users, to citizens, whatever word you want to employ. And so from the perspective that privacy is a recognized international human right, in the EU, it's a fundamental right, as I mentioned. It is the government's responsibility to not only not infringe this right, but they also have a positive obligation to protect it. And so from my point of view, from the legislative point of view, it is absolutely appropriate for the government not only to necessarily come in with the hammer, as in after the harm has been done, but to work with companies and to lay down a baseline standard for what is appropriate and what is not appropriate, what can they do with data, what shouldn't they do with data, to make them reconcile with these questions before the harm is actually done.
You have another question?
Yeah. So I don't know if this is kind of part of the same question, but we see a lot of consumer data put at risk by failure to follow specific security practices, whether it be, you know, password hashing, using not strong enough algorithms, or SSL, and stuff like that. And that's how companies get hacked, and how, you know, regular citizens' data gets exposed, and identity theft and stuff like that can happen. How can you enforce these types of security mechanisms, technical ones? I mean, is there anything like that happening now, whether it's like PCI compliance or something like that, but just standards?
Right. Well, so, you know, generally, and this goes back to our principle of reasonableness, there are not particular standards that we set forth, in part because they are constantly evolving. And so what we are looking for companies to do is take a look at you know, their industry and see what is reasonable, what is going on in your industry, and be aware of that and be up on that, and then incorporate those protections. So ruminating a little bit more on the, you know, the question of whether or not, you know, there would be additional find and fix if we reduced the terms of our orders. I don't know, but, you know, speaking only for myself, you know, I have to think that our 20-year orders are serving a good role. So.
I will flag the really good work that NIST, the National Institute for Standards and Technology, is doing in this space. They work on standards for a host of issues, but they do focus on security standards as part of their mandate. And for example, one of the things that NIST has talked about within our facial recognition process is that there are a host of standards out there concerning biometric identifiers, and one of those standards is a standard practice within the industry to not use a biometric identifier as a sole or even primary authenticator or verifier. right? Because biometric identifiers aren't changeable. You can't reissue those credentials the way you can a credit card number. It's essentially a standard within the technology industry and within NIST's sort of biometric work to use it as a secondary or tertiary factor in identification. You also have to have a token, you have to have a code, you have to have a password, you have to have something else in addition to the biometric, because that biometric, once it's compromised, can be replicated, and you have a fairly substantial security problem on your hands. So to the extent that NIST standards work bears on these issues, as Cora said, it's constantly evolving. And one of the things we have learned is, the pace at which, and God bless our friends in Congress and state legislatures, but the pace at which lawmakers work on these issues really does argue against putting hard and fast technical standards into legislation. Regulation, I think, is slightly quicker, and we see that in the PCI DSS space. We see it in some of the other spaces, but even that moves much more slowly than technical standards advance. So, it's a bit of a catch-22, though I would flag NIST's important work in this area because they really do tremendous stuff.
Thank you. I think that pretty much wraps up our time here today. So thank you, Cora, John, and Raegan for participating. This is a great conversation, and I'd like to thank the CFP organizers for providing this forum for this discussion. And thank you, everyone in the audience today, for joining us today.